nothing but tomorrow. Yes, now the first question, it's framed by me. Let us see that how many people are get the Lawrence today. Mismatch the following part A, title of the case law and what is held in the part B. Part A question, V. Sampath Kumari versus M. Lakshmi Ammal and others. The held is related to the applicability of the section 14(1) of the Hindu Succession Act 1956. B. Mr. Gopalaswamy Iyengar, what is held is this case should be governed by the section 14(2) of the Hindu Succession Act. The C. Moniram Kotla versus Keri Kolitani, and the principle laid down in this, the leading authority established in this principle of this heirs of a deceased female being ascertained after the death of the intervening male heir founded upon. D. Vinit Sharma versus Rakesh Sharma and others. The Supreme Court stated that Section 6 of the Hindu Succession Act provides an unobstructed heritage but to that daughter. I say, which is the mismatch?
Option B. Gopalaswamy Iyengar.
Okay, if I say yes, what would be the right answer for that one? No, it is not the right answer. Gopalaswamy Iyengar, it deals with the section 14(2) and section 8 also. Next, second option.
So first question answer, which is correct?
But you give me the answer options, then I will give the what is the correct mismatch.
Yes, sir.
Second option. Somebody told B, wrong answer. It's not a mismatch, it's a very right. And Sampath Kumari versus M. Lakshmi related to the section 14(1) Hindu Succession Act is very much right. So you decide between C and D.
Option A. Sampath Kumari.
I say decide between C and D.
Option C.
Yeah.
It is option C is wrong because we know the Vinit Kumar already. Vinit Sharma versus Rakesh Sharma, we know it. Section 6. So the right answer is, mismatch is?
Option D.
Arey Allah, my God.
Option D.
Vinit Sharma is the right answer, section 6 only. I say mismatch.
Yes.
Vinit Sharma is a section 6 only. I say mismatch. The right answer is mismatch.
Option D. Option
Again, you are
C.
saying mismatch is D. Section Vinit Sharma is the right answer.
Option C says.
Option C is the wrong answer. That is a mismatch. Again, you are saying D. Vinit Sharma, section C is the right answer. I mean, right. The section is right and the principle, title is right and the principle is right. Is it clear?
Okay.
Then what is the answer for the first question is? D.
Option C.
Thank you. It is C. It is a challenge if anybody give the answer. Second question. The court held that a person is entitled to a decree of nullity under section 25 and subclass 3 of the Hindu Marriage Act on grounds of the fraud as described in the dash of the Indian Contract Act. Section 15, option B, section 16, C option section 17, D option section 18.
17.
Oh, your
Option
shooting is
C.
very right. Answer is?
17. Option C.
Option C is the right answer. Okay. I would like to see whether you can get the hat trick today or not. I am sure that you cannot make the hat trick. Third question. All cases belong to the double jeopardy except one case law. A. Thomas Dana versus the state of Punjab. B. Sangeeta Ben Mahendra Bhai Patel versus state of Gujarat. And the C. Maqbul Hussain versus state of Bombay. And the D. Jitendra Panchal versus intelligence officer?
Option A.
Option B.
WRONG.
Option D, sir.
WRONG.
Option C.
WRONG.
మరి ఏంటి ఆ 4 options?
Option B.
Option B is the right answer. Sangeeta Behan Mahendra Bhai Patel versus State of Gujarat is not connected to the double jeopardy. But can you tell me supplementary question? What is meant by double jeopardy? And which article deals? Quick. If you don't know, you say pass on.
21.
What is meant by jeopardy? A person cannot be punished for twice for the same offense. The famous case law is Maqbul Hussain versus State of Bombay. The fourth question is, I think you might have not seen the feedback. Okay. The criminal procedure rules govern the use of section 9 and 10 have the following benefits. Which one is odd man out? A. Witnesses can be spared the convenience of the unnecessary attendance at court. B. Evidence can be presented simply and clearly. C. Trial can be shortened. D. Cost can be saved. I say which one is odd man out, not related to section 9 and section 10 of the criminal procedure rules.
Option D.
Repeat.
Option D. Cost can be saved.
WRONG.
Option A.
WRONG.
Option B. Evidence can be
WRONG. No, option B is right. Witnesses can be spared the inconvenience.
Okay, section
Oh, that
9.
is not the feedback I have given here wrong. The A is the right answer. The A is the right answer. Why?
Yeah.
Why? It is there on the screen. Why?
Inconvenience. Witness can be spread the inconvenience of unnecessary
There the convenience is there, the right is inconvenience is there. Okay, fifth question. Why you are taking so much time to give the answer when I have shown the both of them and I highlighted in the red also? Fifth question. The use of the provisions requires compliance with the certain formalities set out in the section 9, subsection 2 and the criminal procedure rules. Find out the wrong statement or requirement. A. The statement must be signed by an advocate. B. There must be a declaration of the truthness. And C. The statement must be served properly on their parties within parentheses unless agreed before during the hearing. D. The statement must contain the witness's age at the beginning of the document if they are under 18. Odd man out. As per the section 9, subsection 2 of the criminal procedure rules. Shoot. Take a chance.
Option D.
Say open challenge. Nobody could make a hat trick.
Section B. Section B.
Repeat.
Option B, sir.
Repeat.
Option B.
WRONG.
Option A. A statement must be signed by an advocate.
Suppose if I say it's the right answer, add my note. What would the right? Let I presume that okay, I say right.
Signed by an advocate అన్నారు.
It should be signed by the witnesses. Not by an advocate. You
That
check the
is.
D. The statement must contain the witness's age at the beginning of the document if they are under 18. That gives the hint. Not by an advocate. The statement will be signed by the witnesses. That is the right answer for the fifth question. Okay, 9. Sixth question. The file maintenance case, I repeat, the file maintenance case, you need to submit marriage certificate and photos of your marriage as proof. These are essential requirement to file a case under dash if Muslim can file the family court or judicial magistrate where you reside, not where you reside, where you reside. Option A, Section 25 of the Hindu Marriage Act 1955. Option B, Section 125 of the CRPC. C, Section 6 of the Hindu Adoption and Maintenance Act 1956. D, all the above.
Option B, 125 CRPC.
B, sir.
See, intentionally I created the mistake here. I say all the above. I know that people say D is the right answer. But you did not
Muslim
notice, but you did not notice if Muslim can file a case.
Yes, yes.
If Muslim can file a case, she cannot file a case under Section 25 of the Hindu Marriage Act. She cannot file a case under the Hindu Adoption Maintenance Act, and all the above will not be applicable. Only the B is the answer. Is it clear? Is it clear? Say yes.
Yes.
Good, I appreciate. You cannot make a hat trick. It's an open challenge. Seventh question. Which statement is false statement? A. Section 125 of the code gives effect to the fundamental and natural duty of a man to maintain his wife. B. Section 125 provides a statutory right and can't be affected by personal law. C. The right conferred upon the wife by the provision of the Section 125 is independent of the personal law and to claim the protection Mohammed law in derogation of the statutory provision of the code is permissible. D. A wife is entitled to maintain under the Section 125 irrespective of the fact that she is not entitled to maintain under the personal law.
Option C.
D.
Option C and D answer.
D.
WRONG.
Sir, Muhammad option C.
Suppose if I agree that C is the right answer.
Yes,
It
sir.
is,
Muhammad
right answer means the question is false statement.
false,
If I
false,
agree,
yes.
then what would be the proper word should be there?
Protection of Muhammad law.
The production of Muhammad Allah is already there because Section 125 definitely will make the people, those who wants to get the production from the Muhammad Allah, they will file the case in the 125 only. No, let I admit that your C is the right answer. They say is not permissible. I removed the not. I removed the
Not permission.
NOT not. Okay, now eighth question. Which case law is not connected with the Section 72 of the Indian Contract Act? I repeat. Which case law is not connected with the Section 72 of the Indian Contract Act? Option A, Corporation of Calcutta versus Hindustan Construction Company Limited. B, Sri Mobin Mohammed CM versus unknown. C, Mrs. Lakshmi Narayana Mining versus the chairman. D, Commission of Sales Tax UP versus Auria Chamber of Commerce. Use the technique. Use the equation.
Wow.
What equations are? This is such a tough question that you framed today.
Option D.
WRONG.
Option B, sir.
WRONG.
Option C.
Lakshmi Narayan Mining versus the chairman.
Option C, RIGST, Mrs. Lakshmi Narayana Mining versus the chairman is not connected with the section 72 because it is connected with the impossible performance of the contract. Ninth question. Which case law is not connected with the dying declaration? Sir, we know that dying declaration is Emperor versus Abdullah. And what is Pinnapakala? What is that? Another case law? But I did not mention those case laws.
Akala Narayana Swami.
I know that you will give the answer. I did not mention intentionally. A. Sant Gopal versus state of UP. B. Deepak Baliram Bajaj versus state of Maharashtra. C. K. Ramchandra Reddy versus public prosecution. D. Ramavatar Singh versus Delhi administration.
Option C.
WRONG.
Option B,
Option B,
Deepak.
Deepak Baliram Bajaj. WRONG.
Option A.
WRONG.
Option B.
Option D.
I say it's an open challenge, I said, because for preparing the 9 questions, I have taken the 1 hour. It's not so easy
Yes,
thing.
sir.
Okay, now let us come to our routine job. What is our routine job? Let us start from the back. 100 question. Start out the sequence of the action performed under the Andhra Pradesh Forest Act 1967 with respect to the constitution of a reserved forest. Number 1, proposal notification by the government in the Andhra Pradesh Gazette and the district Gazette concerned. 2, proclamation of the forest settlement officers. 3rd, bar of accrual of fresh rights and prohibition of clearings. 4th, adjudication claims before the forest settlement officers. And option A, B, C, D goes there. Option A, 2, 4, 3, 1. Option B, 1, 2, 3, 4. Option C, 4, 2, 3, 1. Option D, 3, 1, 4, 2. If Sharat Kumar is present, please confirm the answer. If Srivedya is present, please confirm the answer. Shoot.
Option A. 2, 4, 3, 1.
Srividya, confirm. Srividya, confirm. Option A, 10th A.
Option B is the correct answer, sir.
But here the key says it's the 2016 it is. It's the 2016. And the 2016, option A is the right answer, which I have shown on the screen. I don't know which answer that you are looking at. Can I show the question which I have framed it? See, this is the thing which we made it. JCJ examination, question paper, Venkata Lakshmi advocate, Putturu, and we are dealing this one. According to section 2B of the CRPC 97, the charge that we dealt yesterday up to 66 or 64. I think we did it up to 66 if I not be mistaken. Am I right?
Yes.
And the same thing I am reversing order that I am making out now. The reverse order. See here the 100B, the reverse order. But whichever I have shown you, 100B, no. 100B is the right answer for that one. So I have shown the some different other things. 100B is the right answer. That's why you please check it and give me the answer. This is the right answer for these questions. So this answer follow. So B is the right answer. That means 1, 2, 3, 4. Am I right? Say yes. Say yes.
Yes, sir.
Okay, 99th question. The licensing authority cannot refuse to grant license for firearm on the following grounds. A. Person requiring the license is of unsound mind. B. Person requiring the license is below the age of 21 years. C. Person requiring the license does not own or possess sufficient property. D. Person requiring the license has been sentenced to imprisonment on a conviction of any offense involving the moral turpitude. Shoot.
Option A.
Vidya.
Following.
Yes, sir. Correct answer, sir.
C.
Say loudly.
Option A is correct answer, sir.
Option A.
For the 99th question.
Yes, sir.
Yeah, 98th question. Against the order of the Court of the Judicial Magistrate First Class under the Protection of the Women for Domestic Violence Act. Option A, no appeal lies. Option B, appeal lies against any order to Court of Session within 30 days. C, appeal lies to High Court. D, appeal lies only against the maintenance order.
Option B. Appeal lies against any order to Court of Session within 30 days.
Confirm.
No, sir.
Confirm.
No.
So yes, first class to
Second option.
session court. Okay. Option B.
Confirm. Srividya, confirm.
Option D is the correct answer, sir.
For the 98th question, that is the way of killing. Okay, 97th question. Grant of a maintenance to woman who has lived for a substantial period of time with a man without marrying him and is then deserted him is A. Aliman, B. Palimani, C. Palamori,
Option D is
D.
the answer.
Grant.
Option B. Polimony.
B correct answer.
Grant.
B
Yeah,
correct answer.
Srividya, confirm.
B correct answer, sir, for 97th question.
That is the style of giving the answer. Good. So 96th question. Whether injunction can be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the Electricity Act. Option A, yes. Option B, maybe. Option C, no. D, option must be.
Option no. C. Injection can be granted any court order.
C is correct answer, sir.
C no. They.
Okay. Now 95th question. An appeal against any of the past to determine the mental capacity of the juvenile above the 16 years of committing a heinous offense lies to dash. A. Court of Session. B. Chief Judicial Magistrate. C. Children Court. D. POSCO Court.
Sir, option B. Judicial magistrate. Mental
Option C. Children Court.
Confirm.
Option A is correct answer, sir. Court of Session.
Court of Session is the right answer for the 95th question. Okay, now 94th question. In the event of any difference of opinion among the members of the Juvenile Justice Board, option A, opinion of the majority shall prevail. Option B, opinion of the members shall prevail. C, where there is no majority option, the option of the principal magistrate shall prevail. D, 1 and 3. Actually, it's not 1 and 3. It's A and 3. A and C.
Option A is the correct answer.
Option
Yeah.
D. D correct
Option
answer.
D, sir. Both A and C.
It's the D is the right answer. Both A and C is the right answer for 94th question. Yes, 93rd question. The cognizance for the offense under the Wildlife within parenthesis Protection Act 1972 shall be taken by the court basing on dash A police report, B a complaint made by the private persons without issuing any prior notice to the central government or the state government, C a complaint by the authorities under the Wildlife Protection within parenthesis Protection Act of 1972, D none of the above.
Option D.
Option B.
Option C.
C is the correct answer, sir.
C.
Option C is the right answer for 93 question. That is C is a complaint made by the authorities under the Wildlife within parenthesis Protection Act of 1972. Okay, 92 question. As per the section 15 of the Andhra Pradesh Excise Act 1968, for the sale or the buying of the excisable articles within a district, the authority to grant a license is option A, prohibition and excise superintendent, B, deputy commissioner, C, excise commissioner, D, executive magistrate.
Option C.
Option A.
Option A is the correct answer, sir.
So option A, prohibition and excess superintendent is the right answer for the 92nd question. Okay, 91st question. Who among the following does not fall under the expression public servant is defined as defined under the Prevention of Corruption Act 1988. A option any judge, B option any arbitrator, C option member of the Legislative Assembly, D option an unpaid worker in a government office assisting the regular government servant.
Option D.
Yes, sir. Option D is correct answer.
Very good,
An
very
unpaid-
good. Subalata, you are making the hat trick, but you did not make the hat trick with my questions. 90th question. The special court constituted under the 36 of the Narcotic Drugs and Psychotropic Substances 1985 can try the offences which are punishable with the imprisonment for a term of dash. A. More than 5 years. B. Less than 1 year. C. More than 7 years. D. More than 3 years. Are you hearing me?
Yes, sir. Now it is audible.
Yeah. Did you hear my all 90th question options?
No, sir. We did not hear your
Yes,
option.
because I know that because it's not recorded. I know it because I know what is recorded, what is not recorded. 90th question. The special court constituted under the 36th of the Narcotic Drugs and Psychotropic Substance Act 1985 can try the offences which are punishable with the imprisonment for a term of dash. A. More than 5 years. B. Less than 1 year. C. More than 7 years. D. More than 3 years.
Option C.
No.
No. It's
Second option. Should.
Option D, sir.
option A. 5 years.
Yeah, confirm.
No, sir.
Say the right answer.
Less than 1 year. Huh? B option B.
And 1 year.
D.
Option B. Less than 1 year.
Yes, yes. Less than 1 year is the correct answer.
So B is the correct answer for the 90th question. In the 9th question, sentence awarded under the Narcotic Drugs and Psychotropic Substance Act of 1985. Option A is suspended as per the provision of the CRPC. B can be remitted as per the provision of the CRPC. C can be commuted as per the provision of the CRPC. D cannot be suspended or remitted or commuted within parentheses other than the sentence under the section 27 of the Act.
Actual
Option
subject
D.
is public trust.
Should.
Option D.
Yes, sir. Option D is correct answer. So for 90th question also option D is correct answer, sir. More than 3 years.
Okay,
For
okay, okay.
okay.
Shall I proceed?
Yes, sir. Yes, yes.
88 question. Presumption provided under section 118 of the Negotiable Instrument Act does not apply to the following. A. Consideration. B. Date. C. The holder is holder in due course. D option. Execution of the instrument.
Option D.
Option-
Execution of the instrument.
Yes, sir. Option D is the correct answer.
Okay, 87th question. In an appeal against the judgment of the conviction of the offence under the section 138 of the Negotiable Instrument Act, 1. The appellate court may order the appellant to deposit sum which shall be the minimum of 20% of the fine or compensation awarded by the trial court. Number 2, the amount payable as above shall be addition to any interim compensation paid with the appellant under section 143 capital A of the Act. A is correct and B is wrong. Option B, A and B are wrong. C, A and B are correct. D, B is correct and A is wrong.
Option C. A and B are correct.
Yes,
Actually,
sir,
there is
both
no
A.
A and B. I said 1 and 2.
Yes.
Yeah. Okay, let us presumption because our mind will read. Even there is 1 and 2 also we can say A and B.
Yes, sir.
So-
Option C is correct.
Srividya.
Yes, sir. 1 and 2 are correct, sir. Option C is correct.
Very good, very good. 96. Whether the special court constituted under the section 14 of the Scheduled Caste and Scheduled Tribe within parentheses Prevention Atrocity Act 1989 can take cognizance of the offence directly. A. No committal is necessary. B. Option. Yes, committal is necessary. C option. Committal is not necessary if the offense is committed after the Amendment Act 1 of the 2016 came into effect. D. Depending upon the nature of the offense, special court can take cognizance directly.
Option A.
Option B.
Confirm.
No, sir. Wrong answer.
Other options.
Option
B.
C.
Option C is correct answer, sir.
The committal is necessary if the offense is committed after the Amendment Act of 1 of 2016 came into force. That is the answer for the 86th question. Now, 85th question. Whether the victim under the Scheduled Caste and Scheduled Tribe, within parentheses, Prevention of the Atrocities Act 1989, has got right to be heard at the time of the hearing the bail application or the discharge petition moved by the accused. Option A, yes, subject to the granting of the offense. B, no victim has no right in any circumstances. C, depends upon the discretion of the court. D, yes, in all cases. Shoot.
Option A.
Option C. Depends on the description of the D.
Confirm.
Option D is
Option
correct.
Option B.
Option D.
Means yes in all the cases.
All cases.
Okay, 84th is the production of the Civil Rights Act 1955 prohibits untouchability for A. Enforcing the religious disabilities, B. Enforcing the social disabilities, C. Refusing to sell goods or render any services, D. All of the above.
D. All of the above.
All of the above.
All of the above is the correct answer.
83 question. In the case of the offense punishable under the 494 of the Indian Penal Code 1860, who can make a complaint? A. Any social institute. B. Neighbors. D option. Mother, father, brother, sister on behalf of the wife. D. All of the above.
Option
All of
D.
the
All
above.
of the above.
D, sir.
No, sir. Option D is
Confirm.
not correct answer. Option C is the correct answer. Mother, father, brother, or sister on behalf of the wife.
Can you tell me what is the section 494?
494 under
Bigamy.
What is section 494? Vidya.
Marrying again, sir, during the lifetime of husband or wife.
Good. That is the
Bigamy.
answer. If you do so, what time of the offense committed?
Punishment of bigamy.
Very good. 82nd question. Disclosure of the identity of the victim of certain offences is punishable under section A. 225 capital A of the Indian Penal Code, B. 228 of the capital A of the Indian Penal Code, C. 225 capital B of the Indian Penal Code, D. 229 capital A of the Indian Penal Code.
Option D. 229A.
Option B, 228A.
Option B is correct answer, sir. 228A of Indian Penal Code.
Yes, the right answer is B. 228 capital A of the Indian Penal Code for the 82nd question. Mean the 82 question. 81. If a person having been charged with an offense and related to bail or bond without sureties fails to appear, Sumarita, mute, without sufficient cause before a court in accordance with the terms of the bail or bond, A. He has committed no offense. B. Option. He has committed an offense and is liable for the punishment. C. Option. His sureties are liable for the punishment. D. Only warrant can be issued against him for disobedience.
option C.
Option B,
Option D.
committed an offense.
Committed an offense.
Option C, sir.
He is correct answer, sir. He has committed an offense and he is liable for punishment.
Yeah, option B.
Confirm.
Option B is correct answer, sir.
He has committed an offense and is liable for the punishment.
Yes, sir.
Okay, 80th question. A. Knowing that his effects are about to be taken execution in order to satisfy the debt due from him to Z, destroys those effects with the intention of thereby preventing Z from obtaining the satisfaction of the debt. Option A, he has committed no offense as he has damaged his own property. B, he has committed a fraud. C, option A, has committed a mischief. D, option, he has committed a criminal breach of trust. Shoot.
Option B. Option B, fraud.
No. Option B is wrong answer.
Option C.
Option D.
Option C is correct answer.
A has committed a mischief. Say yes.
Sir.
Okay,
Yes, yes.
79th question. If a father or mother of a child under the age of 12 years leaves the child in any place with intent to abandon such a child, A, it is not an offense. B, it is an offense. C, it is an offense only if such child dies. D, none of the above, and the child care is only social obligation.
Option B, sir.
Option B.
Option B is correct answer, sir.
It is an offense.
Yes, sir.
78.
It's an offense.
Suppose if the child age is 14 years, now you give me the answer.
Below 12 years, no
Even
offense.
below the 18 years, I think it is an offense. To my knowledge, I don't know. Because a minor cannot be given in such a way. Okay, once it become a major, then you can do anything, whatever you want. Okay, 78th question. A forged promissory note and filed the suit. Option A is punishable for the forgery of record of court. Option B, A is punishable for the forgery. Option C, A punishable for both A and B. D, option D, all of the above are correct.
Option C, sir.
B.
Yes, sir. Option B is correct answer. A is punishable for forgery.
Okay. It is a forgery. What is the difference between forgery and fabrication?
Fabricating of facts.
And forgery is something ditto, you can make it out. Okay, next question is 77th question. A makes an attempt to steal some jewels by entering into the house of a B through a window and finds after so entering the house that there are no jewels but only books and leaves the house without taking anything. Option A is guilty under the section 511 of the IPC. B, A is guilty under the section 453 of the IPC. C, A is guilty under the section 453 and 411 of the IPC. And D, A is guilty of no offense because he did not find the jewels. He found only the books, and which is used as
Option
stealing.
C. Option C.
Option A. Option A is the correct answer.
No, sir.
Option D.
No guilty of no offense.
Option
C.
Option C is the correct answer.
A is guilty under the 453 and 411 of IPC. The point is, either the house door is open or he has broken the house. Doesn't make any difference. But when he has broken the house, generally we will say burglary. Am I right?
Yes, sir.
A dwelling place. In burglary, always the place should be a dwelling place. Either is a farmhouse, or is your rented house, or is your own house. Okay, next 76th question. A instigates B to murder D. B, in pursuance of the instigation, stabs D. D recovers from the wound. Which of the following statement is correct? A is not guilty of instigating B to commit murder. B is guilty of instigating A to commit murder. C, A is guilty of instigating to commit murder. D, none of the above.
Option C.
Yes, sir. Option C is correct answer.
A is guilty of instigating B to commit the murder. But he did not
Yes, sir.
instigate to whom that he said. That is called in the terms of the legal terminology. Suppose you want to kill B or you want to beat B. But when you are giving the punch to the B bend down and C receive the punch. Now you tell me what type of the terminology you can make it out. In the both the way it is an offense. Either you give the punch to the B or you give punch to the C. Both are said to be the assault. I mean battery. That is called in the terminology transferred intention. Repeat.
Transferred intention.
Yes, I appreciate. So now the 75th question is a proclamation of persons absconding under the section 82 of the Code of Criminal Procedure 1973 requiring him to appear must be published giving dash time to the concerned person. Option A, not less than 110 days. Option B, more than 2 months. Option C, not less than 20 days. Option D, not less than 30 days.
Option D.
Option D, 30 days.
Option B.
B is correct answer.
B,
Not
B.
30 days.
Confirm.
Option D, sir, not less than 30 days.
Not less than 30 days is the right answer for the 75th question. Now, 74th question. The time space within which three offenses of the same kind committed by an accused can be charged together is dash. A, 6 months. B, option 1 year. C, option 2 years. D, option 3 years.
Option B, 1 year.
Option B, 1 year.
Yes, sir. Option B, 1 year is the correct answer.
Even though he committed the three offenses.
Yes, within the year.
If he committed 3 murders, 3 times hanging.
No, sir, only once.
Okay. Now the 73 question. The set of period of detention of an accused during trial is available against option A. Option A, the term of the principal imprisonment alone. Option B, the term of the principal imprisonment as well as the imprisonment imposed in default of payment of fine. C, the term of the imprisonment imposed in default of payment of fine and alone. D, the accused is not entitled for set off under any circumstances.
Option A, the term of principal imprisonment alone.
Yes, option A.
A is correct answer, sir.
Okay. Now, means A is the right answer.
Yes, sir.
Okay, 72 question. Who will decide the quantum of compensation payable to a victim in terms of the victim compensation scheme under section 357 capital A of the Code of Criminal Procedure? A, the concerned court. B, the district collector. C, the district legal service authority or the state legal service authority. D, the state government.
Option C.
Option C is correct answer, sir. Either DLSA or SLSA.
Yes, because 357 is the compensation paid, and this will be under the control of the either district legal service authority or the state legal service authority or the national service authority. Am I right?
Yes, sir.
71st question. A is tried upon a charge of theft as a servant and acquitted on the same fact of the theft. Whether A can be charged with a criminal breach of trust? Option A, no. A is entitled for the benefit of section 300 CRPC. B, yes, the charge being different, the subsequent prosecution on the ground of the breach of trust is permissible. C, there is no legal bar for a fresh prosecution. D, A may be charged with the permission of the court.
Option B.
Option B.
No,
Option D.
no.
He may be charged with. Option C.
Option A is correct answer.
So, A is entitled for the benefit of section 300 of CRPC because once he is acquitted on the same ground, he cannot be charged again. Is it?
300 CRPC.
But it's a double jeopardy in other sense. Am I right?
Okay.
A person cannot be prosecuted for the same offense twice. 70th question. where a person is required to produce a document by a criminal court, whether he shall personally appear and produce the document before such a criminal court. Option A, he shall appear and produce the document in person. B, he shall take permission for dispensing with his appearance. C, it is sufficient if he causes such a document to be produced before the court instead of attending personally to produce the same. And D, he shall produce the document and give evidence in respect of the document.
Option D, sir.
Option C.
Option C is correct answer, sir.
Means it
It
is
is sufficient.
sufficient if he causes such a document to be produced before the court instead of attending the personally to produce the same.
Yes,
Okay,
sir.
now
Option C is
suppose if it is a document, it is written by him, and when you ask the question, can he send the document with somebody else?
no.
At the time, he himself should have to come over there because
Yes, sir.
he will be asked the question that based on that document what is written over there. Okay, 69th question. At the time of the pronouncement of judgment by the subordinate appellate court, A, the accused shall attend to hear the judgment, not to her the judgment. To hear the judgment. B, unless the appellate court otherwise directs, the accused is not required to attend to hear the judgment. C, the accused is not required to attend hear the judgment. The attendance of the accused is required even though it is acquittal of the accused. General order
Option
question.
C.
D, sir.
C.
No.
Option D.
Either he
Option
is
A.
acquitted or he is
Option A.
convicted. Accused must be present. Am I right?
Yes.
Confirm.
Option B is correct answer, sir.
Repeat.
Option B. Unless the appellate court otherwise directs, the accused is not required to attend to hear the judgment.
Is it? Unless the appellate court otherwise directs. The accused is not. Okay. At the time of the pronouncement of judgment by the subordinate appellate court. Okay. Because there is a confusion one, because criminal procedure, no, there is a. Okay, 68th question. If the accused pleads guilty under the 228 of the Code of the Criminal Procedure, the judge A shall convict the accused. B may in his discretion convict the accused. C shall bear the prosecution. D need not hear anyone. Within 5 minutes it will be closed. Quick.
Option C. Shall hear the prosecution.
No.
Right answer?
Option B, sir. May in his discretion convict the accused.
Okay, the
Discretion.
discretion is given to the judge. Yes, 67th question. Without instituting a suit, who can apply the petition to a principal court of original jurisdiction for its opinion, advice, or direction in respect of the management or administration of trust property other than the question of the details, difficulty, or importance for summary disposal? A, any interested person in the trust. B, any two persons from the public. C, any trustee. D, no one can file an application, only suit shall be filed. Give the answer. Time is left.
Option C is correct answer, sir. Any trustee.
Any trustee is the right answer for what one. 66th question. Let's say a minor ordinarily resident of Nellore, temporarily camped in the Visakhapatnam. The property of the minor is situated in Anantapur. In which court the application of the appointment of the guardian of the property of the minor can be filed? A, at Nellore only. B, option either at Nellore or at the Anantapur. C, at Anantapur only. D, at Visakhapatnam.
Option C.
C.
Option C is correct answer. Where the property is situated.
Okay.
Anantapur.
In a private international property, we will say dispute, lex situs, where the property is situated, that country law would be, or that place law would be applicable over there. Yes, 65th. Which of the following statement is correct? Natural guardian is always entitled to the guardianship and custody of the minor. Welfare of a minor is always paramount per consideration for the guardianship of custody. A and B are correct. Where is the A and where is the B? B alone is correct. C A alone is correct. D, neither A nor B is correct. I think he has made A is a natural guardian, is always the entitled to the guardianship and custody of minor, and B, welfare of the minor is always the paramount per consideration of the guardianship of the custody. That might be the A and B. Now you
Option
tell.
C.
Option B alone is correct.
Option B alone is correct. That the welfare of the minor is always paramount per consideration of the guardianship of the custody. Okay, 64th question. When the buyer wrongfully neglects or refuses to pay for the goods, when the goods are passed to him, the seller can dash A, recover the goods delivery, C, B option, claim damages, C option, file a suit for the recovery of the price of the goods, D, none of the above.
None of the above.
Option B, claim the damages. Option B is correct answer, sir.
He can claim the damages, he cannot keep your point. Which of the following are not goods? A, stock and shares. B, growing crops. C, grass and things attached to the land agreed to the service received under the contract of sale. D, money and actionable claims.
Option D.
Yes, yes.
Yes,
Option D is correct.
currency is not a goods. Then what is currency? Say, Parson, I will give you answer. Currency is not a goods.
Yes.
Then what is that?
Sir, is a electrical form.
Say, Parson, I will give the answer.
Pass on, sir.
Thing. 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 Okay. 62 question. X executed a sale deed in favor of the Y and presented for the registration on the 10th January 2020. Registration was kept pending for some time, and at the last, the registration of the document was effected on 10th March 2020. Option A, the document operates from the 10th March 2020. B, the document operates from the 10th January 2020. And C, the document operates 10th day after its presentation. And D, the document operates from the date of the delivery of the possession of the property. Shoot, at any time it will be closed.
Option D.
Option B, the execution date comes into purview.
The document operates from the 10th January 2021.
Yes, sir. Option
Okay,
B
now
is
the
correct.
61 question. An unregistered agreement of the sale of immovable property of the value of the 100 and upwards. A, can be received evidence of any transaction affecting such property. B, can be received evidence of the contract in suit for the specific performance.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनि तव उदार वाणी